Hi everybody, welcome back to Law Hero. Today is an FE1 video. So if you're doing constitutional law this winter, or indeed whenever, whether you're QLTT, FE1 or the King's Inns, this is applicable to you. So obviously sometimes you are asked about, the principles of constitutional law, and you know what they are. One of them might be a presumption of constitutionality, for example. I have them listed here. The double construction rules. If there's two meanings given to an interpretation, the constitutional interpretation will be taken, and that comes from MacDonald v. Board Nagan. There will be judicial deference, usually to the executive branch. For example, like in tax, there'll be the non-justicability, there'll be a mootness, you'll always need locus standi. There is a new type of constitutional principle. Now, it's not new as in it's not a new concept, but it is a fairly novel area of constitutional law in Ireland. It was asked as question 6, September 2019. The question was, the Supreme Court's recognition of NVH of a power to defer the making of a declaration of unconstitutionality has the potential to radically alter the principles and price of constitutional litigation in Ireland. Do you agree? That essay is about constitutional principles, but you would have need to have known NVH and what he means by the principles and pricing of constitutional litigation. So suspended declarations, which was the point of that, which was a big part of the NVH judgment, is what we're talking about in this video. This was a Supreme Court ruling which held that even though there was an absolute prohibition on asylum seekers under the Refugee Act 1996 seeking employment, and that this was contrary to the constitutional right to employment. But how they phrased it was in principle unconstitutional. So they didn't outwardly say that this provision was unconstitutional. They said it was an excessive violation of the unenumerated right to seek employment found in Article 40.3 of the Constitution. And it's a very significant judgment. Now, we're not going to worry too much about being in direct provision and needing to work, because that's not why we're here. We're not here for the refugee side of it. What we're here about is the delayed ruling on the invalidity of that section, because what they did was they postponed or they suspended their declaration of unconstitutionality for another day. It has been argued by some scholars that, okay, because this person was not yet a citizen, they weren't being denied their constitutional rights, and because it wasn't like they had been in the workplace and now they were suspended, they had never worked anyway, that the situation wasn't so urgent, so it wasn't so bad that there was a delay on the decision. But then the question arises, okay, well, what if this happens again in a different context? Talk about the invalidity in principle of that section. So the court said, since the situation arises because of the intersection of a number of statutory provisions and could arguably be met by alteration of some or one or other of them, and since that is the first and foremost a matter for executive and legislative judgment, I would adjourn consideration of the order for 6 months. Okay, so what they're basically saying is that a law needs to be made around this to clear up this matter, but they suspended their ruling for 6 months. So the court declined to make an immediate ruling about the constitutionality of the statute and deferred it while encouraging a legislative response. So they found a constitutional problem, but they did not invalidate it. And this has rarely been done in the Irish courts, and that's why he asked the question. And that's why it looks like a suspended declaration, which is not what it actually was, but it's like that. And that has been seen in other common law jurisdictions, like in Canada, where they suspend the invalidation of the whichever section of the legislation is at issue. That being said, this can also be problematic for the people who are being affected by the judgment. But there's also a benefit that goes with these kind of judgments or declarations, that the consequence of invalidating a piece of legislation is very, very serious, and the courts are more willing to invalidate laws if they're empowered to suspend the effect. So what they're basically doing is saying, okay, we're not going to say outright it's unconstitutional, because we know what that means for everybody who has had their rights violated. What we're going to do is hopefully send a message to the executive and the legislator to quickly make orders and legislation around this issue. My information from the UCC Constitutional blog, which is really, really excellent. Okay, so let's just go back to what the question was. So let's see, can we answer it now? So the point was around the deferral of the case for 6 months, and then the principle. So now we have a principle whereby, even though you have a presumption of constitutionality, there is this new type of backstop whereby the court can suspend their declaration of an invalidity, hoping that the legislator will intervene. As regards cost, this means that the plaintiff has to wait longer. Here it was 6 months. So that's why litigation will be more expensive. Now, to talk about COVID and proportionality, we all know that there was emergency measures introduced at the start of COVID-19 pandemic in Ireland, and there's been some high profile cases brought, likening Ireland to Nazi Germany, for example, and that was thrown out by the judge. But however, it did raise an interesting point around personal liberties, public health, and proportionality. Now, proportionality is an administrative law or public law. It comes from the civil German law tradition, Verhältnismäßigkeit, which is used in German law an awful lot as a yardstick to tone down a remedy or to balance rights. That's what it basically does. You see it also in criminal law as well. For example, if I kick your dog, you can't just come and stab me, no matter how much you love that dog. That would be proportionality in action, and that makes sense as well, because criminal law is a public law area of law. But in constitutional law, it's not sanctioned by the Constitution, but because administrative law and actions against the public and the relationship between the citizen and the state, proportionality is important to basically yardstick how draconian a state can be, and how that affects its citizens' rights. Under the Health Act 1947, which was the piece of legislation which was amended to bring in the COVID measures, there was restrictions on social gatherings, and you basically had to limit your travel, okay? So, like, landlords were prohibited from increasing rent, which is a property right. They couldn't evict tenants until the emergency was over. And that was the 30th of June, I think. And businesses as well were required to limit or cease trading until restrictions had been lifted. And you saw that with like hairdressers and restaurants, and pubs are still restricted to trade. So this is a massive infringement of, well, right to earn a living for, we'll say, publicans, hairdressers and all of those people. Property rights for landlords, and we learn all about these in constitutional law, and indeed they're all in the book. So then where does proportionality come into all of this? So you might remember as well, if you've ever done international law, like self-defense needs to be, necessary, proportionate, reasonable, all these kind of things. And it's the exact same when it comes to balancing public health and COVID with the rights of private individuals. So the considerations would be the objective of the action and whether it's legitimate and important and warrants interference with constitutionally protected rights. And this all comes from the jurisprudence of these rights, which is set out in my chapter. Whether there's a rational connection between the objective and the means chosen to realise it, whether the state action is necessary to achieve the objective, and whether an appropriate and proportionate balance has been struck between the public interest and common good and the particular impact on rights and interests. As we know, the courts show deferential treatment towards the executive in their carrying out of the legislative mandate. So we would imagine that the courts would stand by their guys, and they sure did when people went to challenge the legislation. But what about the property rights? Because as we know, you couldn't kick out your tenants even if they were acting up. I don't think it was an unjust attack on landlords. I mean, there was a blanket approach to this, so I don't actually think that group would have been compensated, just like I don't think that business owners would be compensated for their time being out of business. Otherwise there would be floodgates. So I do think that perhaps there will be some kind of question around this in the next constitutional law exam. I really do. I'd be shocked if there wasn't. It is a massive constitutional question, the interference with people's constitutional rights. So yeah, I hope you enjoyed this video. Please stay tuned. I really enjoy making these videos, and yeah, I love discussing it. I'm not an academic, I'm just a lawyer with an interest in this stuff. So yeah, please like and subscribe for more.